My father, a self-made man who pulled himself up to the heights of entrepreneurship, was never a fan of trade unions. Matter of fact, he believes that they are the reason why businesses struggle because of the ridiculous demands that they make of employers. I grew up with such beliefs. And when I worked at the bank, I spoke to a lady who had a really horrible experience when she needed SASBO, now called the finance union, to help her with an issue. It seemed as though she had given her money away to people who never even wanted to listen to her side of the story. Despite my experiences, I realized the extent to which trade unions can be a force for good. They have the potential to change industries for the better. McDonald's in Denmark was pushed back when they never wanted to collectively bargain and understand the labor laws of the country. So the trade unions of the country collectively organized in a sympathy strike, which destroyed nothing but the bank balance of McD's in that country. That was in the 80s. But today things are pretty much different for trade unions. Memberships have all but gone down, and the shifting nature of work and technology may, if left unabated, render trade unions obsolete. As an employer, I, just like my father and countless other business owners, looked at trade unions as a necessary evil. However, as an employee, I now look at them with a more open mind. In this lesson, I want to present a case for trade unions, their roles and responsibilities, the impact which they have had on business, and perhaps a little background. What is a trade union? A trade union may be defined as a group of workers that have organized themselves with the aim of being able to negotiate with their employers using the process of collective bargaining. Keep in mind that it is in the best interest of South Africa to have a stable and productive workforce so that it can sustain a level of economic growth. The main aim of any trade union should be to represent the workers when they negotiate with their employers and help them to improve their working conditions. The Constitution of South Africa gives employees the right to join a trade union and to participate in the activities of said trade union. The Constitution goes a step further and guarantees that employees must have the freedom of association and the right to engage in industrial action. Remember, rights are only rights if they are not accompanied by responsibilities. Before any protest, the correct procedures must be followed. Trade unions need not be registered. However, if you want to start your own trade union, you will have to register it with the Department of Labor. And your trade union must have a written constitution, and the constitution must be in line with the Labor Relations Act. The trade union may not be associated with any political party. Workers can join a trade union as members, and union members pay a membership fee to the trade union each and every month, and they will then attend meetings from time to time. They'll also elect office bearers to manage the affairs of the union for a certain period. The relationship between employers and workers, or between businesses and trade unions, is normally called labor relations or industrial relations. The roles and responsibilities of trade unions in South Africa. To achieve their main aim of improving workers' conditions, trade unions negotiate with businesses about workplace issues. These negotiations are called collective bargaining because trade unions negotiate on behalf of the workers as a group. Collective bargaining is good for workers because it gives them more power by standing together. It also saves businesses the trouble of negotiating with each of their workers as individuals. In South Africa, the law allows workers to go on strike if they cannot reach an agreement with an employer. But for a strike to be legal, the union must follow a strict procedure. The procedures to have a protected strike are as follows. The issue over which the employees seek to strike must be referred to the CCMA, or the Commission of Conciliation, Mediation and Arbitration. The CCMA has 30 days to resolve the issue. If the case is not resolved, then a certificate stating that this is the case has to be issued. For businesses operating in the private sector, 48 hours notice must be given for the strike action. Government departments, that period is 7 days. If all of this has been done, then the fun may begin. The employees may go on a protected strike. During a protected strike, employees may not be dismissed for participating in the strike, but if they destroy something or do something illegal, then they may be dismissed. If, on the other hand, the strike was not protected, then the employer may fire workers who participate in the strike. It will be an unprotected strike if the correct procedures are not followed. If there is a collective agreement that says that workers will not embark on a strike action for that particular matter. Any workers which work in essential services are not allowed to strike. The South African police services, parliamentarians, and services which, if disrupted, may endanger the health and safety of the population are all considered essential services. Let's talk a little bit about the CCMA. The Commission for Conciliation, Mediation and Arbitration is an independent dispute resolution body funded by NEDLAC, or the National Economic Development and Labour Council. Their whole reason for existing is to settle disputes between employers and employees, so that labor unrest does not ever happen in the country. The CCMA will first try conciliation, where they will meet with the employer and the employee to seek ways in which they could settle their disagreements with a mutual agreement. If that does not work, then they will try mediation, but only if a possible strike is planned. If not, then they will try arbitration, where a decision is awarded. This decision will be legally binding on both parties. If, however, one of the people involved in the process feels that the decision is incorrect, then they have 6 weeks to refer the matter to the labor court. I find the case of Teresa Mulderich very interesting because she worked for a company since 2018, and when COVID happened, she was one of the employees who refused to take the compulsory vaccination as stipulated by her company. She took her employer to the CCMA, but at the CCMA she lost her case. It is interesting to note that she went through this whole entire process on her own. She did not take it up with a trade union. And my questions are, was she even a member of a trade union?
Thank you for joining us for this lesson. If you learned something, please give this video a like, share, and subscribe.